Good morning, this is your Kelso Report for Friday, June 29th, and I'm your host, Clark Kelso. Well, the Supreme Court surprised pretty much everyone in National Federation of Independent Businesses versus Sibelius by upholding the individual mandate in the Affordable Care Act under the taxing power. Now, as you may recall, before the oral argument in this case, I had forecast that a majority of the court, led by Justice Kennedy, would strike down the act under the Commerce Clause. While I was correct about the interpretation of the Commerce Clause, a majority of the court did vote that the act was not authorized by the Commerce Clause. I did not forecast that Chief Justice Roberts would then turn around and find the individual mandate was actually a proper exercise of the federal government's taxing power. As you know, under the Act, a person who fails to secure insurance under the individual mandate must pay a penalty, which is collected by the Internal Revenue Service. Now, the court's prior cases have generally distinguished between the taxing power and the imposition of a penalty. So the key question is whether the individual mandate and penalty operates as a tax, in which case the mandate is authorized, or operates as a penalty, in which case it is not authorized by the taxing power. Even though the Affordable Care Act repeatedly refers to the payment as a penalty, and the supporters of the bill and the President at the time repeatedly asserted that the act was not a tax, Chief Justice Roberts found just enough indicators in the bill to characterize it as a tax, notwithstanding the contrary statutory language. For example, the Act makes it clear that the only consequence for failing to follow the mandate is the payment of the tax penalty. No jail time, no other fine, it's not a criminal act. The amount of the tax penalty is determined by the usual factors that affect taxes, such as ability to pay. And the tax penalty is administered by the IRS. So the Chief held that the mandate was authorized as an exercise of Congress's broad taxing power. A different majority of the court, this time by 7-2, also held that Congress could not force states to accept a significant expansion in Medicaid, as authorized in the Act, by threatening to withdraw all Medicaid dollars from states that refused to accept the expansion. The court held that that condition was coercive. So states will now have the freedom to decide whether to accept the additional federal monies that go along with the expansion in Medicaid coverage. I think in California we clearly will be accepting the additional federal funds. If enough states decide not to accept that expansion, it is going to be, I think, a problem for the rest of the Act, because the Act was balanced in the way it had the Medicaid expansion versus some of the insurance programs. Now, in terms of the development of constitutional law, I think it's difficult right now to tell how important this case may be. On the one hand, a 5-4 majority clearly has indicated a limit to how far Congress can go with the Commerce Clause. But it is not the majority that ultimately carried the day on the Affordable Care Act. So one wonders about the strength of that holding. And because of Roberts' treatment of the taxing power, the court has effectively laid out a pathway for achieving a form of market regulation that would otherwise be beyond Congress's power. But that is not exactly anything new, since everyone agrees that the taxing power, when it's invoked, can affect activity not otherwise within Congress's enumerated powers. However, Congress will get to play this type of a game, the game of telling everyone that it is not a tax, only to have the court treat it as a tax anyway, only one time. In the future, there will hopefully be greater political accountability at the time a measure is being considered by Congress for whether the bill before it is actually a disguised form of taxation. In any event, the court here has clearly thrown the ball back into the political arena, and the continued viability of the Affordable Care Act will now become an issue in the fall elections. I suspect public attention will turn very quickly away from the court, and the public will focus on implementation of the Act and the politics of the elections. court had a second important case yesterday involving the First Amendment, and here there really was no surprise. The split was the normal one. Kennedy had the lead opinion and involved the First Amendment. The Stolen Valor Act makes it a crime to falsely claim receipt of military decorations or medals, and the defendant was prosecuted under that act. Well, in United States v. Alvarez, the Supreme Court struck the act down under the First Amendment. As you know, content-based restrictions on speech receive heightened scrutiny. Generally, there must be an important or compelling governmental interest, and the statute must be narrowly tailored. In this case, the court concluded that while the government's interest in protecting the integrity of the Medal of Honor was beyond question, there was no evidence supporting the government's claim that the public's general perception of military awards would be diluted by a false claim such as those made by the defendant. In addition, the government had not shown why counter-speech, such as the ridicule the defendant received online and in the press when discovered, would not suffice to achieve the government's interest in protecting the integrity of military honors. It should be noted that all of the justices agreed on the legitimacy of the government's interest. The only real disagreement in this case was whether there were less intrusive means for protecting and furthering that interest. The Ninth Circuit had an immigration single case yesterday involving immigration. In Nyan v. Holder, the Ninth Circuit joined 5 other circuits in holding that it has appellate jurisdiction to review the decision of the Board of Immigration Appeals denying asylum in what is known as an asylum-only proceeding, even though the board in such a proceeding does not enter a formal order of removal, which is the normal basis for judicial review and appellate jurisdiction. The petitioner, a native and citizen of China, had his petition for asylum denied by the board. Because he had arrived in the United States as an alien crew member, his asylum proceeding was limited in scope in what is known as an asylum-only proceeding. And in this context, the board never issues a final order of removal. The Ninth Circuit held that the denial of asylum in this context is the functional equivalent of an order of removal. So the Ninth Circuit held that jurisdiction was proper. And then on the merits, the Ninth Circuit affirmed the denial of asylum. So in this case, the denial of asylum was tantamount to an order of removal. Kind of like having a penalty actually be a tax. So just another example, courts sometimes have to reinterpret words to get to the right result. Next, we have a California Court of Appeal case in In Re MM. A unanimous California Supreme Court held that a school security officer is a public officer for purposes of Section 148 of the Penal Code, which makes it a misdemeanor to willfully resist, delay, or obstruct any public officer, peace officer, or emergency medical technician. Law enforcement personnel have long been considered a public officer within the meaning of this section. A school security officer is a public safety officer employed by a school district and charged with ensuring the safety of school district personnel and pupils. Although not sworn peace officers, school security officers work in partnership with local law enforcement to achieve the statutory goals of ensuring the safety of persons on public school premises. In concluding that a school security officer is a public officer, the court noted that the legislative history of Section 148 reflects that the term public officer had long been understood to include public officials and employees who perform law enforcement-related duties in connection with their office, and that plainly included school security officers. As a result, the court affirmed the conviction of a minor who had resisted or delayed a school security officer who was trying to break up a group of youths engaged in school vandalism. Next, in United States Teachers of Los Angeles v. LA Unified School District, the Supreme Court of California held that a court should not order arbitration of the interpretation and application of collective bargaining provisions that directly conflict with provisions of the Education Code. That is, if they would annul, replace, or set aside education code provisions. The issue arose in the context of a decision by the district to approve the conversion of an existing public school into a charter school. The union argued that the conversion violated terms in the collective bargaining agreement and demanded arbitration, and the district resisted on the ground that the relevant provisions in the agreement were in conflict with state law regarding charter school conversions. Although the Supreme Court affirmed the law that provisions that are directly in conflict with state statutes should not be submitted to arbitration, the court remanded to the trial court for a fresh and detailed consideration of exactly what provisions in the collective bargaining agreement really were at issue, and of whether they conflicted with state law. An interesting statutory interpretation case in the California Court of Appeal in People v. Diaz, where a jury had convicted the defendant of first-degree residential burglary, false representation to a police officer, and misdemeanor possession of burglary tools. The defendant challenged the sufficiency of the evidence to support her conviction for possession of burglary tools. The prosecution demonstrated that she possessed latex gloves and a large purse, but did not demonstrate that she possessed these items to break into or gain access to a victim's property. Since these items are not obviously the sort of burglary tools expressly mentioned in Section 466 in the Penal Code, things like Slim Jims, a floor-safe door puller, or other similar items, the 4th District held that the evidence was insufficient to support a conviction for possession of burglary tools. So it's okay to continue to carry latex gloves and a large purse without fear of immediate arrest. So that's it for today's report. Have a great day in the law.